So let us return to copyright. The goal of this speech is to talk about old, same, but about the same thing, what should be protected when speaking about copyright, and what is copyright protected work, and in order to prepare for case solving. Those who are dealing with intellectual property mostly will know what I'm going to talk about, but I hope for some it will be useful. At the same time, I enclosed some information on the latest case law, two already with judgments, and one still in the phase of litigation. But those three cases will be related to my topic. I will talk about these cases at the end of my speech. Now, on the notion of work, and this definition of work, the notion is quite important when we talk about copyright. Because the understanding of this notion allows us to cover or give the scope to the protection, as well as to restrict the scope. So the notion or definition of work has been our initial task, whether the work should be protected or is the protected object or not. And only then we think of some restrictions or refusal for registering, etc. From a procedural point of view, defining the work is an issue of rights, not the issue of de facto. Even if both parties believe that the work is a protected work with copyrights, does not exclude a court from defining it ex officio by itself, whether it is protected work or not. In the CV case that was mentioned initially, both parties were also agreed upon the definition, although it was a sui generis case. But in any case, the ECJ had to define whether the work should be and is protected or not. Let's return to procedural aspects. The issue of work being a protected object, that should be evaluated by certain criteria. I will define those criteria, and you will be able yourselves to try your skills to define whether the object is protected or not. It can be based on different facts, on different circumstances, but the burden of proof lies on the person who seeks protection. The notion of work, from a Latvian perspective, the answer is quite simple. We open copyright law, Article 1, Paragraph 2. Work is a result of creative work of an author in literature, science, or arts, irrespective of its form, type, and value. The notion of work has been explained also by ECJ's case law, and it's an autonomous notion and definition. That's why in Latvia, when applying this copyright law, we have to take into account ECJ's case law, and we have to interpret this notion accordingly. This notion is dynamic. It is constantly developed by new case law. Also, how we define one criteria from another, whether it is a sub-criteria or permanent criteria, as well as its content is being supplemented in the case law of ECJ. First question that might arise for us as professionals, we can see that, let's say, it is literature, science, or art as a trace. Thus, we should try whether the object of dispute belongs to one of these areas, but at the same time, we have to be quite careful, because this list coming from Berne Convention is just descriptive. It describes the protected area where with several elements, the whole range of elements is being described. That's why it should be interpreted broader. In ECJ's case law and in other countries' case law, I have not seen someone applying only those three words as criteria, whether the object belongs to literature, science, or art. In Latvian case law, there have been attempts to do so. Also, when speaking about video games, district court used this subsumption, saying that the work does not belong neither to literature, science, or art. But as I said, these areas are not decisive. Other criteria are more decisive. Looking at ECJ's case law, wherever there might be, let's say, some disputes on, let's say, cheesy taste, or football games, or others, there were opinions expressed saying that the work did not belong to any of those three areas, but the ECJ based its decision on the criteria of originality, saying that football games are not protected and the cheese taste cannot be identified. That's why it is not sufficient. One more time, let's be cautious with this enumeration of definition. Another aspect that I have also seen in second instance judgments, also enumeration of notion of work and its dynamic. Berne's Convention again quotes these three areas. Belonging to one of those three areas, it does not mean that the work is and should be protected first. Also, this list is not exhaustive. The last words are "and other areas." And other areas. So application of rights should start with seeing whether the work belongs to any of those three areas, but should not end with this list, which is not exhaustive. Whenever there is a dispute, or whether the work is protected or not, historically there was such a dispute with specific computer programs. Now they are protected with copyrights in order to avoid any disputes. Zane also said on public performance, in this administrative case where there was this video gaming, I did not want to comment on related rights or related claims. We have to answer the question, what is protected in computer games? It contains visual, audio elements, and the system, gaming system, or complicated gaming system is also an object of copyright. And if we would agree to this opinion, we could say that the player is a performer, because there's a work that someone performs. But audio-visual work is not performed. Actors perform scenarios. They are not performing audio-visual work. So initial task would be to define an object of copyrights. The screen is tired. That's why it's switched off. Let's move on to certain criterions or preconditions. In ECJ practice, there are two cumulative criterion developed. Both should be found in order to define one object to be protected. Criteria of originality or creation and identification. Those should be related to all copyright objects. Historically, there was no common understanding on this, because in EU law, nowhere can be found a definition of work. In several directives, you can find specific works, like databases, like photography, also computer programs, but it was not clear whether all types of work should have the same treatment. And gradually, these two criterion should be related with every work. But at the end, I will tell about one case from Germany where still the question remained on applied art, whether there should be some additional criterions applied for that. This question is still asked and asked from national courts. One of the most difficult questions for ECJ to answer, as well as for national courts to answer, is on minimal level of protection. What is the simplest protection, the minimus principle? And there are some examples, but no one unified application. ECJ has given a verdict that one word or separate word cannot be protected as a work. But there are national cases where this issue is contrary. Another aspect should be taken into account: exceptions. In the law, there are objects enumerated that are not protected with copyright law. Our law says the copyright law does not protect certain works. The erroneous word is word. The enlisting contains several notions that cannot be considered as works. For example, the word idea. Idea is not a work. It's nothing tangible. These exceptions are not harmonized in the EU legislation area, but we have to take into account one exception that is regulated by Berne Convention concerning official texts which can be protected by national law, depending on its decision and discretion. If you are more interested in that, you can find C 622, Advocate General's Medina decision on this issue on what cannot be protected by copyright law if not separately decided upon by national legislators. Criterion of originality. What is the criterion of originality? It's taken from Directive 2006 11.6 from recital 16. The work should be created by an author, by its intellect, and relate his personality. It's quite difficult to understand what is mentioned, what is meant by author's own intellectual creation, reflecting his or her personality. So let us look at the originality criteria. It should be the result of creative work. Raise a hand those who have not seen this picture. I think everyone has seen this picture. You haven't seen it. Okay. A wonderful picture. Concerning this picture, there have been several disputes regarding it. This tale is the following. David Slater, a photographer, went to Indonesia where he wanted to take pictures of this type of macaque monkeys. He said later that he spent several days to make friends with these monkeys, but not too friendly. So he left his camera, put it on an elevated podium, and also provided with a button to push. A monkey is very curious, used this camera and pushed the button, and there have been several hundreds of pictures made. This is not the only picture that has an amazing result. David even used these works commercially. He earned several thousand based on a license, but then in Wikipedia there were several publications and photography. But this author said that he has copyrights on this picture. Initially, Wikipedia removed this picture, but then later placed it back, considering that if the picture was not taken by a human being, it can and it should not be protected. So it can be used by anyone. Relatively, there were disputes in the USA, but of course there were related discussions in the EU. What if we had to deal with this case? Mainly, the conclusion was that this picture is not protected because it was created by an animal or other animal than Homo sapiens. Similar conclusion was made also by USA Copyright Agency, who registers copyrights, as well as dealt with by Appeal Institution and Supreme Court of USA, with the same conclusion that this object is not protected. Second thing, when PETA, Animal Protection Organization, spoke on behalf of the monkey, saying that all income from this picture should be distributed or managed by monkeys. Interesting question, and why we grant copyright protection to someone. And it goes hand in hand together with our case law on AI. This is the same basic question: who should be protected? In Europe, main the decision is based on Kant and Hegel's philosophy, saying that a human being should be protected, and his self-expression results and individual expression results should be protected. He as a person and his creation should be protected. This is mainly the concept of personal rights and copyrights. This spiritual connection between the author and his or her work. That's what we believe in Europe. USA, they have different opinion. They believe that copyright should exist in order to stimulate or to foster creation of new copyright works, like kind of an incentive. So do we grant rights, copyright rights to AI? There is no clear answer. Someone believes yes, some no. Okay, I told you about the monkey. Initially it was said that the author can be a natural person. And it is not relevant whether the person is capable of acting, and irrespective of his or her mental and physical capacity. If he has created a work, he has rights or copyrights. In Germany in 2014, there was a case when there were an author, and the author actually doubted that she is the author. She said the following. She wrote a literary work, material, and she, as if was dictated by Jesus from Nazareth, as she said, historic personality, another person, not a deity or divine person, and it was dictated. There is no impetus from her, so the work should not be protected, or her copyright should not be protected. German court very broadly disputed, and later on decided to grant the copyright rights. She opposed, but she could not prove that she had it dictated from above. So this burden of proof, especially when speak about metaphysical images, notions, creatures, then there's always question. If you act by someone's command, you should not be granted copyrights. Next question to you. The Latvian work by Bruno Salmanis, Chris Salmanis, kinetic installation. In the middle of the room, a 8-meter high tree is attached, and by swindling one way and the other, the tree creates wind-like sound. The question whether this tree is protected by copyright and whether Chris Salman is the author. Those who consider Chris Salman is to be the author of this work, please raise a hand. Okay, those who consider only the tree not to be protected. No, tree to be connected. No one. Okay, no one. So there should be an intellectual work. You take, let's say, very often an interesting branch or a root and say that it's a piece of art. In this situation, you do not get any copyrights for that work. But then you ask a question on this specific execution. And then there is this moment that you can be granted copyrights if there is a specific context or given to the spatial object, or them being placed in a specific combination or a context that can be copyrighted. Either the element or the context or composition of elements placed in certain order can be copyrighted. Another interesting thing, historically there have been attempts, those who believe that a tree being brought in the gallery could be copyrighted. Those represent presentationen. If you present something, then you have rights. But this is a minority of believers in this concept. There is also a book written about this concept of certain elements being presented as objects of art. But majority believes that no. And connecting with AI, everything that you create from images offered by the AI, then you present something that, according to you, is an object of art. You will not be granted copyrights for that if you apply this concept to AI. There are no copyrights granted when autonomous technical processes perform the creative activity. You can, for example, look at Google Maps, our hotel from above. These pictures or images are taken in an automated way, not only from satellites but also by planes. According to certain set parameters, they take pictures. And the question is whether someone can claim copyrights for this picture. The picture is taken automatically, and if so, it's not a created work. There is no impetus, no creativity. Another example, or different example, would be, let's say, works in the library are scanned by people, by a specific scanner. And again, as these books are scanned automatically, these cannot be copyrighted as well. Again, going hand in hand with our topic of AI. I could say that we are talking about editor of a text as a tool. We are, let's say, using Word as an editor when writing our letters. We are authors, yes. We create and we use text editor or spell check as a tool. And automated translation, we do not have any impact on how it is being translated. We can choose between several automated tools. We choose the best or correct it a little bit, but we cannot be authors of the text. And in the middle, there are AI systems that are generative, depending on how much the process of creation is impacted by a person. According to that degree, we can either speak about or not a copyright being provided. So whether it's an autonomous tool or very, very impacted process by a human being. In other words, how much a person controls creation process. Criterion of originality. If we speak about creative process and control, an important aspect is what has been said by ECJ's case law, whether the author had freedom of choice. And as I mentioned, ideas are not protected. What is protected? The expression of those ideas. And the question whether after expressing the idea or expressing the idea, a human being was free in choices, or whether it was the only solution. He was very restricted. The ideas are not protected. According to the doctrine, you cannot monopolize ideas because that would harm any progress, which is common good for the benefit of the society. That's why we have to conclude that specification of an idea, its result can be copyrighted. And ECJ's case law, we are looking also at technical considerations or limitations or laws. In this case, Brompton bicycle, this bicycle can be folded in 3 different ways. 2 can be seen here on the screen, and the third one is placing it on one wheel, kind of upright. There are specific technical functionalities for reaching those one or several elements of form are chosen. But the question is whether there was a freedom of choice for a creator in order to come up with these designs, or technical aspects were the ones dictating this outcome. Another example on rules is what I've already mentioned. Football association, football game cannot be protected because football is a game with certain rules. Here we can dispute whether we play all about the rules, or there is a freedom of choices. We had also a dispute of a photography of a landscape in Latvia. The court decided that photographer was free to take this picture from any angle which corresponds to this criteria also prominating in this case law. This aspect that the idea could be expressed in different ways is not a decisive factor for freedom of choice. If we need to acquire a specific technicality, those technicalities might be reached with limited resources, and then this idea can be copyrighted. How to understand what the ECJ said, namely on that this choice by the creator was done in a creative way, describing one's personality. And in these cases that I've already mentioned, national courts were trying to define or understand what does it mean. And the question then, when we come and state, yes, there was a freedom of choice, and then we have to step a step forward, whether the author has used its own intellectual creation reflecting his personality, not by considering that he or she wants to fulfill a technical peculiarity, which is quite subjective and difficult to prove. And the applicants also, in these cases, stick to that opinion, namely what was the motivation of the author by choosing one or the other implementation method for the idea. One of the aspects that might be taken into account based on the fact whether it is the result of creative work, subjective novelty, which is a widespread argument usually for defendants, that there is nothing new in this specific dispute. I remember in Latvia we had a dispute on format of TV broadcasts, news broadcasts, I believe, was the object of dispute. And the question, how does it differ from other news everywhere else around the world? It might be the argument, indeed, that the creativity should be expressed not with repetition but with novelty. Maybe that's the issue. But how to state this subjective novelty? Because we are not, we don't have to come up with everyone admitting that it is a novelty, but that the creator subjectively should consider his work or her work to be a novelty. And these are issues that ECJ and not only are trying to deal with. Some examples on criterion of originality. This is the initial case, InfoPack case in 2009 on text copyright protection. And as I already said, one word cannot be protected with copyright, but a phrase or a part of a phrase could be protected. This is what ECJ said. In this specific case, there were phrases containing 11 words, 5 words before a keyword and 5 words after the keyword. And the question whether these fragments of 11 words can be copyrighted. ECJ did not say yes or no in this specific case, but the opinion was the following, that these short fragments could be protected. The criterion of originality has been fulfilled. Another question on photographies. I will tell you what aspects could be taken into account when evaluating photography similar to literary work, style and choice of words, placing of objects. This case was divided in three processes: how an angle was chosen, the lighting, framing, the photography itself, and after treatment of a photography. Maybe it was treated or some filters applied, so three stages of creativity for criterion of originality to be fulfilled. Again, remember AI, you can impact something and you can correct the result or impact some of those stages. Here we can see the example of the dispute. On evaluation process, I already said this is a tricky issue where we don't have measurable parameters. There will always be some subjectivity. However precise the evaluation criterion might be, and the judges should kind of divide everything in certain elements, but keep the overall picture. Because the decision on whether the object is protected or not is on object as a whole, not as its parts or process parts. It's quite difficult for courts, let's say, when we talk about IT systems or architectural objects, when without experts we cannot decide. Interesting whether object is later decided by specialists to be unique, whether it is an indication of originality. This is a preliminary question to ECJ by German court. What is not of importance, how much time and energy was invested to create something, also the expenses and subjective aesthetic evaluation is not a decisive factor. Identification criterions, it is that the work should be rather precise. It should be specific expression of an idea to be considered copyrighted. Like in Levolo case, ECJ said that it is precisely objectively identified this specific taste. According to existing technical level, one cannot decide upon it. Maybe in the future we will be able to name the taste or describe the taste, and maybe later on we can protect smells, perfumes, and tastes and smells. There have been several cases in national courts, and some of them even found it possible to copyright sounds and smells. Tastes and smells. Also, it's interesting that ECJ said that the work can exist for a short period of time. In Latvia, we also had a dispute on flower carpets in Ventspils. We annually make flower carpets, whether it can be protected, and the first instance rejected it on the basis of its durability, that it exists for only a short period of time. And the second instance court said that the time is not a decisive factor. and satisfied the claim by granting copyrights. Finally, on these two cases, I will not read out questions. You see them on the screen. Dispute is between creators of two producers of tables, claimant and defendant. And the question whether the claimant's table on the right-hand side can be copyrighted. And how to apply the criterion of originality. Is it a decisive factor if an author has an explanation for his idea or her idea why this table was created in that or this way? And what's the level of protection? What Sweden believed itself believed in the principle of de minimis, and they believe that if only de minimis protection is granted, it impacts negatively innovation and competition. And this is also a question of subjectivity and novelty, whether we have to look at everything that has been previously created, elements, round and flat element being put together. If this combination is compiled in a different way, only then we proclaim it to be a novelty and product of creativity. How to evaluate specific breaches, whether certain elements were copied or the idea of the work as such, or the image that is being created, or maybe the copy. Through the copy, we can recognize the original. It comes from Pelham's decision, where there were 2-second fragments from pieces of music. And the court concluded that such short fragments can be used if they cannot be recognized as certain previously created works. And now the last case from Germany that I already mentioned on applied art objects, pieces of furniture, to producers of furniture. Quite similar, I should say. The question whether these objects of art should undergo the test of more stringent requirements for originality. And then again, why the author made these decisions. Do we use evidence, circumstantial evidence, or do we just consider that the author was free in his choices and came up with this idea irrespective of previously existing pieces of art?